Showing on Law Weekly today, we bring you another view, that of Mr. Femi Falana, SAN, on the Supreme Court judgment nullifying the return of Bayelsa State Governor-elect Mr. David Leon and his running mate. We also have the opinion of another senior advocate of Nigeria, Tayo Oyetibo, on the moves by the Senate to amend the country's constitution, plus the views of some young ladies on the anti-sexual harassment bill, and of course our weekly recap of the top trending stories from the courtrooms. Hello and welcome to the program. I am Shola Shoyeli. Last week on the program, we had the views of two senior lawyers on the Supreme Court judgment on the Bayelsa governorship seat. It was interesting and generated plenty of debates and reactions. This week, we bring you another view. Senior advocate of Nigeria, Femi Falana, thinks that the Supreme Court lacked the jurisdiction to have entertained the matter as it was a post-election matter. Here's his view.
The mistake made by the court, by the Supreme Court, and you can't blame the court for what has become a culture, is that a pre-election matter was turned into a post-election matter. I've looked at the provisions of the Electoral Act. I've looked at the relevant provisions of the Constitution. I've not been able to locate any section of the law that empowers any court in Nigeria, including the Supreme Court, with profound respect, to cancel an election that has been concluded on the ground that a candidate was challenged before the election. Because as far as section 31, subsections 5 to 8 of the Electoral Act is concerned, what should be done? If any candidate feels that, any person feels that a candidate has given wrong information based on fraud or whatever, you can complain by filing an action at the Federal High Court or a State High Court. Once the court comes to the conclusion, subsection 5, that the information is wrong and that the person is not qualified, the court shall, at subsection 6, disqualify the candidate from contesting the election. And the political party involved, subsection 8, shall be penalized, sanctioned, and be asked to pay fine, the sum of 500,000 naira. Those are the penalties prescribed by law. No other penalty is prescribed by law. And what that presupposes is that the case has to be concluded before the election. Hence, the law says the candidate shall be disqualified from contesting the election. In the case of Bayelsa State, the election was held on the basis of the judgment of the Court of Appeal, which was to the fact that, yes, this guy changed his name many times. Not that he forged any of the certificate. There was no such proof. Therefore, he can contest the election. On the basis of that judgment, the people voted, which means by that judgment, the election was valid and legal. As of that date, there was no pending appeal before the Supreme Court, whereby INEC could be accused of having violated the doctrine of lis pendens, i.e., since you knew a case was in court, why did you hold the election? As was the case in the case of Obi and INEC, Peter Obi and INEC. So it was after the conclusion of the election that the PDP filed an appeal in the Supreme Court. With profound respect, the attention of the Supreme Court was not drawn to the legality of that appeal. The case had become spent. So what their lordships ought to have done was to say, as the lawyers, can you address us with respect to our jurisdiction? Because Section 133 of the Electoral Act stipulates that upon the conclusion of an election, and once candidates are declared, any challenge of the conduct of the election or the qualification of the candidate shall be heard and determined by an election petition tribunal.